Okay. I remembered my question. It has to do with representation. So when I asked you just the couple, you said, well, actually, it would just be one side of the couple. So can you go into why it's important that each side have their own attorney?
Yes. So that is the law in California, is that each party has to have an attorney look at it. So, and that is from the marriage of Bonds case. It was about Barry Bonds's, one of his marriages where he did not do that, in addition to some other things he didn't do. One of the rules became that each party has to have their own attorney. What I've seen becoming more and more popular is people mediating premarital agreements and then sending their clients to each have it independently reviewed. Technically, I think that's allowed and fine, but I think it's worrisome for a couple reasons. One is that if they've done the work with one person and they've paid the money and they feel like they like the draft, I don't know how much of a real look they're allowing their individual attorneys to do. So when people come to me and a mediator has referred them and they say, oh, we mediated it and they recommended you to review, how quickly can you do it and how much will it cost? They're not really asking me to make a lot of changes. So for that reason, that's one reason that they should each have their own. Another is that if there's some kind of power imbalance, it's not a true meeting of the minds and fair negotiation, even if it may feel like it at the time. So it's better to have that distance of each party having their own. And because even in the best of circumstances, they're still paying someone else to look at it. As I see it, they may as well just each get their own to begin with and just bring the draft together instead of doing it together and then potentially having it blow up in some way. And then the last reason is that, to me, if you're in a divorce and you're going to present a judge with a premarital agreement or a postmarital agreement, I would want it to be the least vulnerable to being set aside possible. As soon as you introduce something that is potentially going to make the judge uncomfortable because it's not really the way premarital agreements and postmarital agreements were designed to be done, you just introduce that problem. And if there's anything else wrong with the premarital agreement, or the judge has a problem with it, or there's anything conflicting in the language, that can be reason enough for the judge to say, well, and you know what? You did this together with one person, and this person was saying that person was biased. And you just introduce a reason to make it weaker.
So there's like doubt almost. Okay.